Hello everyone, my name is Giovanni Nogales. I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Associations for Home Care and Hospice. Today's webinar is entitled Preventing the Revocations of Your Home Health and Hospice Agencies from the Medicare Program. Tips on avoiding an adverse action and on responding to such an event. Today's presenters are Christin Thompson and Matt Catoe. Matt practices in the area of the healthcare regulatory compliance. Matt has experience with auditing claims, anti-kickback statutes, and Stark law allegations, and assisting clients in regulatory cybersecurity compliance. He has also assisted providers with mediation and compliance documentation when on appeal. As for Christin, she's an associate at Lyles Parker. Before joining Lyles Parker, she has worked as a professional coder, assigning diagnosis and procedure codes for the urgent care, inpatient, and outpatient facilities. She has experience identifying documentation deficiencies and auditing claims for a variety of practices types. Christin assists providers nationwide with developing and implementing policies to improve documentation and coding practices. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the question box, and we will address as many as possible at the end of the presentation. So without further ado, I present your speakers, Matt Catoe and Christin Thompson.
Thank you, Gio. Like Gio said, we are going to go through the revocation of your home health and hospice agencies from the Medicare program, how to avoid that, and how to respond in the event that the inevitable strikes and you are unfortunately revoked or removed from the Medicare Medicaid program. A brief disclaimer before we get started: the following slides are presented as general advice only. While Christin and I are attorneys, we are not your attorneys, and this advice should not be used generally, nor in place of advice rendered by duly retained and licensed legal counsel. Next slide, please, Gio. So a brief agenda on your screen, the table of contents. We're going to go over 22 reasons for revocation, generally speaking, as well as the fastest way to lose your Medicare number and how to avoid doing that. We are also going to go over what happens if the worst happens in terms of the caps, the reconsideration, and DAB or ALJ appeals, as well as touch briefly on stay of enrollment motions or actions as those have come up recently in recent years. We do want to point out that this is not covering survey or certification appeals. Those are separate items and will not be covered over the course of this agenda. Next slide, please. So in no particular order, the top 22 revocation reasons are listed on your screen. They can be found at 42 CFR 424-535A, which is a whole bunch of legal jargon to say these are openly published, as well as reiterated and somewhat touched on in the Program Integrity Manual at Chapter 15, Section 15.27.2, if you want to look at hard copies of these certifications. The general ones are on your screen. The ones in bold red are the most common and most likely to appear in your personal capacity in the event that you find yourself on the wrong end of one of these appeals. Obviously, on your screen is felony conviction. This can mean any felony within the past 10 years that CMS finds to be detrimental to the Medicare program or its beneficiaries. You want to think generally here about fraud with a capital F convictions, as well as any procedure under the Anti-Kickback Statute or False Claims Act, followed by false or misleading information on your application. This kind of goes hand in hand. Do not lie to the government. They do not like finding out that the truth is something different than what you told them, and they will take it out of you and your corporation. Others are on-site review or reliable evidence that the requirements for the Medicare program were not met. There may be some kind of hardship exception or denial that you applied for and did not receive, fees that weren't paid, or misuse of billing number, among others. Next slide, please. One of the most common ones that we've seen is the quote-unquote abuse of billing privileges. This is billing for deceased beneficiaries 3 or more times in a row. Impossible for the provider to have rendered services. These are going to be services that take place over an extended course of time that cannot possibly have occurred in the same span of time. We usually see some form of these interacting in terms of a provider bills for more than a number of hours than there are in a day. as well as there is not equipment on site or otherwise available when a service that requires said equipment was allegedly provided, or there is a pattern or practice of billing errors. We will touch more on that later in this slide deck, but to point out that error rate does matter, and CMS and their contractors can and will use a consistent, or what they believe to be consistent, failure or pattern or practice of billing errors, and they may utilize it to start looking towards revocation. There's also a failure to report changes. This is another option to revoke if they fail to report an adverse action or a change in location. So for everybody looking at new office spaces, new leases, work from home, or any combination thereof, keep in mind that the government does require that you stay up to date and keep them informed on where your practice is physically. And if that practice location changes, you need to make sure that you update the government accordingly. This plays into number 10 on your screen, non-compliance with documentation regulations and requirements, as well as home health agency, Medicaid billing privileges generally being revoked, and improper prescribing practices, among others. Next slide, please. So on your screen right now, the big one here is affiliation that poses an undue risk. This is generally going to be associated with excluded individuals who are on the Medicare, Medicaid exclusion parole list. They are not to be affiliated with your business. This means not working for you, nor in any way materially involved with Medicare, Medicaid procedures. Otherwise, you run the risk of getting revoked yourself. Think of it as they take the whole ship down with them. You want to generally avoid working with anybody on the revocation list, as well as anybody on the quote-unquote forbidden or banned list. These are all very public and available, and they are on you as a business to do your due diligence and make sure you are keeping up with them. Debt being referred to the U.S. Treasury is usually part and parcel with one or more audits of a lower level where the government alleges you or your practice owe a certain amount of money. You want to make sure you stay on top of that proceeding, especially if they do make mention that they are going to refer that debt to the Treasury, as it can turn around into a revocation proceeding. Abusive ordering, certification, referrals, or prescription of Part A or B services, items, or drugs can also get you on the revocation list, as well as patient harm by physician or an otherwise eligible professional. And finally, any False Claims Act judgment within the last 10 years can be utilized as a revocation proceeding and can bring revocation matters to a head rather quickly. Next slide, please. So the fastest way to lose one's Medicare number is to point out that most of the 14 revocation reasons are pretty rarely used. Others are much more common and fall into the pretty basic categories you see on your screen. Number one being enrollment problems. Once again, this is a failure to report a change of location, a failure to timely revalidate, and failure to report an adverse legal action, as well as a change of ownership, management, or managing employees with felonies in their record. The next one right behind that is operational problems. This is a failure to keep regular business hours, any lack of proper signage or signatories, as well as employing excluded persons from the exclusion list that I just went over. Lastly are billing problems. Repeated high error rate claims on a TPE or UPIC audit showing a consistent pattern, as we went over previously, can very quickly result in a enhanced oversight and eventually a revocation proceeding, as well as making sure that while you are under a period of enhanced oversight or a PPEO review, you either remain in compliance with the requirements of that PPEO, or if you do fail, the government can utilize that as a means to increase scrutiny and look towards revocation if you fail a PPEO audit. Next slide, please. So reasons 3, 4, and 9 on the previous screen are anything related to a felony with false or misleading information and a failure to report change. Generally, this applies to owners or management employees who have obtained or are serving out a felony within the previous 10 years. That will increase scrutiny towards a revocation proceeding. There's also responsive information left off the application, usually an adverse action taken against one or more providers or the company as a business institution. If that is not on your application, otherwise left off, or in some way deliberately misconstrued so as to hide it or squirrel it away, that can be grounds for revocation. as well as, once again, failure to report change of location or the death of an owner or managing employee. It's on here 3 times because it is very important. Make sure that you are updating the government if and when either your business changes physical location or mailing address or place of operation, as well as when major ownership changes happen in terms of who is the last person to be in charge, did they pass, and if so, when did that change of ownership occur? Generally, in order to avoid this, you want to keep your enrollment records up to date. You want to avoid, to the absolute best of your ability, using a P.O. box or a commercial mail service as a practice location. Sometimes people say that this is cost prohibitive or they don't want to pay to maintain a personal mailbox. In response, we ask whether you'd like to pay to maintain a personal mailbox or pay to deal with a revocation proceeding. The decision is yours. We encourage you to look at option A of not using a P.O. box or commercial mail service as opposed to dealing with a revocation under it. Secondly, know your enrollment obligations. While Christin and I are very good attorneys and we can explain them to you based on the paperwork we are given at the time of an audit or when we start looking into your matter, generally, despite us being very lovely people, most people don't want to work with attorneys, especially on a revocation proceeding. Don't make it harder for anybody. Know your enrollment obligations ahead of time, keep in compliance with them, and stay on top of them. Finally, keep copies of everything you submit. This is a paper trail issue. And the more you can turn over to us from the word go, the less we have to go looking for, the faster the audit turns around, and the better outcome we can have if you have a copy of documentation that proves your compliance with the standards as they were laid out before you. You want to track your mail for paper submissions under a similar mentality. If you can show that XYZ went out the door in compliance with Medicare, Medicaid requirements on X date, whatever X happens to be, it's a lot harder for them to argue, nuh-uh, no you didn't, or any variation thereof. Finally, if you are using PCOS, you want to print the entire submission out of the PECOS system as soon as that is submitted. The faster you can get that turned around, the easier it is for you to keep eyes on it and make sure that you are staying up to date. Next slide, please, Gio. Speaking of the enrollment regulations that we are encouraging you to keep track of, here's where they are codified at Chapter 42 of the Code of Federal Regulations, subsection 424.510. First and foremost, you have to be truthful when you are filling out an application for the Medicare Medicaid program. You cannot lie to the government. They do not like it, especially if they find out later that you lied to them and have been taking their money under a false pretense. They will turn around and they will take it out of you specifically. Only an authorized representative may sign. This is an individual who has the authority to bind the provider or the supplier, both legally and financially, to the requirements set forth in this chapter. Usually this is going to turn around into some form of an owner or executive excuse me, who can make decisions and bind the truth of the company and speak on behalf of the company or agency. If a biller or outside credentialing person is preparing the applications, I cannot stress to you enough how much you need to protect yourself. You want to be sure to review the application, make sure all the material in that application being submitted on your behalf is truthful and accurate, and only the authorized representative or delegated individual that should have been previously identified may sign such an application. I currently have a client out in Kentucky who is dealing with this exact problem where their name is on too much of these forms for them to not be aware in some form or format of the contents of the appeal. They are in front of the government trying to explain why there are several $1 million worth of allegedly fraudulent charges. Don't let that be you. Next slide, please. So generally, the reporting deadlines are on your screen. You have to know what you can report before you can do it. So we made this generally handy table. You have about 30 days from the change of ownership or change of control, as well as a change of authorized or delegated representative. And if you have a final adverse legal action, you have 30 days for Fed or state licensure revocations or suspensions. Otherwise, 90 days from the date of that final adverse legal action. Since failing to report certain changes are the #1 reason for revocation that we get calls about, here are the rules on what to report and when. They are found in Chapter 42, Code of Federal Regulations, 424.516, for home health and hospice. We will talk more about adverse legal actions in a minute. And finally, once again, if you change your practice location within 30 days, that needs to be reported to Medicaid so that they can appropriately update your tables. Any other changes to any section of the CMS 855 form, you have about 90 days for a material change to be reported timely and be considered in good compliance. Next slide, please. Oh, I'm sorry. Hold on. State licensing laws also mandate that reporting deadlines, so be aware of the reporting deadlines if your state holds true to them. Any change of location must be reported to the Texas DADS 30 days in advance of the change of location. CHOW forms, including changes in over 50% of the ownership, require advance notice and the filing of the application, ideally 30 days in advance of that closing. But they can be they can be later if you pay a late fee, so long as this is reported to the government and in accordance with everything prior to the closure. Now, next slide, please. Sorry, Gio. Revalidation. So revalidation requirements, this is getting back in to Medicare, Medicaid. Requirements are found at Chapter 42, Code of Federal Regulations, subsection 424, 515. You must revalidate every 5 years upon request, and missing that deadline can result in payment hold, stay of enrollment, or deactivation of your Medicare, Medicaid account. You need to check the CMS website regularly for due dates and instructions. They are updating this every 2 months, and the link to check is on your screen. If it is due within 6 months, your organization will appear on that list of this organization is going to have to revalidate within 6 months of the time that you are checking. Once you see yourself on the due date list, as soon as reasonably foreseeable or possible, you need to submit your revalidation. The more time you give yourself, the less headache you're going to have once you run up on a deadline. If you have not yet completed your revalidation, you will get an email or letter about 2 to 3 months before that due date. Make sure your correspondence address and email are up to date on your enrollment record. This plays tangentially into what we've been over already, making sure your physical address and place of operation are up to date with Medicare, Medicaid, so that they know where to find you and send you important notices like this. Fees will apply over the course of the revalidation process. Home health and hospice will pay about a $730 fee to revalidate as of 2025. PICOS will prompt you to pay before submitting the application, and you want to go to the link on your screen to pay and print proof to send with your paper application. Just show that you've paid your fees, you're timely, here's the receipt of it. If you miss your deadline for any reason, don't, but if you do, don't despair. You send your application as soon as possible, and you should be reactivated, but there may be a gap in effective dates, which can turn around and affect how and when you get paid for claims or services rendered during the gap in effective dates. Make sure your paperwork is up to date in the revalidation program. Next slide, please. So general traps for the unwary. This goes back to our history of representing providers and doing provider enrollment paperwork over the years. If you take a paper application or send a paper application, use a trackable mail format and print the proof of delivery. This can be very helpful if you are revoked or have to prove you otherwise sent documentation timely. If you must use the U.S. mail, send it certified mail with a return receipt requested, priority mail, or express mail so that it can be tracked. This goes back to paper trail earlier, so that it is harder and harder for a government employee to say any variation of "nuh-uh, we didn't receive it," or any variation thereof. If you use PICOS, save your PICOS in submission confirmation. The contact persons on a PICOS application should receive all confirmation emails when that application is submitted. If you don't get one and you are the contact person on that application, something is wrong, and you should address that quickly. PICOS can be confusing. Regardless of whether you're using paper applications or PICOS, keep copies of everything sent in or submitted so that you can lay hands on it, know generally what time it went out the door, and you can provide a paper trail if and when one is necessary. If you do use PICOS, always, always, always print your application at the end of your session and keep a copy of that application along with your submission confirmation, including an email and screen print. All attachments and signatures are uploaded, or the authorized rep can e-sign during the time of a PCOS application. You want to make sure that even if you do miss the deadline, you are sending the application anyway. In most cases, you will be okay. The only real issue that we have seen, generally speaking, is that gap in effective dates of coverage. Providers are often asking what they should do if they miss a reporting deadline. Once again, in virtually all cases, the answer is send the application. Contractors have been instructed not to revoke for missing a deadline unless a site visit has already been attempted and failed, or revocation for another reason is already pending. Do not say, well, I missed it, I'll try again next year. It's the short version of that. Send your timely annual or semi-annual revalidations as you have to, so that you are up to date on your coding, and make sure that you don't get tagged with a technicality and a revocation because of that technicality. Next slide, please. So, moving into everyone's favorite F word, felonies. CMS is very strict about reporting, screening owners, managing employees, officers, and directors for any felony conviction that has happened in the past 10 years. Generally, you want to make sure that any felony within the previous 3 years is reported as an adverse action on your CMS 855A forms, regardless of what that felony is. It does not matter if it's fraud, drugs, battery, vehicular, anything. Make sure it is on that form. If the government finds out later that you failed to or otherwise deliberately hid information while filling out this form, they will be mad about it, and they will come asking a lot of questions, usually under the veil of some form of auditor. Applicable regulations state CMS may use its discretion to determine if a felony is, quote, detrimental to the best interest of the Medicare program and its beneficiaries. There are 4 types of felonies that CMS will automatically find detrimental. Generally, the felony crimes against persons, including rape, murder, assault, etc. Felony financial crimes, income tax evasion, insurance fraud, embezzlement, as well as any felony that places the Medicare program or its beneficiaries at immediate risk. This is conviction for criminal neglect or misconduct, as well as any felony that will result in any mandatory exclusion. This is going to be all of the above 3 categories, plus any unlawful manufacturing, distribution, prescription, or dispensing of a controlled substance. Check the pharmacies. Make sure the pharmacies are not prescribing anything that they're not supposed to. If you are an owner or managing employee, officer, or director, and you have a felony conviction within the last 10 years for any reason, they likely need to be removed from the organization and from your Medicare enrollment record. If removed and you submit proof within 15 days of revocation notice based on a felony conviction, CMS has displayed a history and likely will rescind the revocation based on those grounds. We don't want to point fingers, name names, or say that people cannot rehabilitate or reform, but for purposes of protecting the business, if one of your owners, operators, managers, directors, or executives has had a felony conviction for any reason within the last 10 years, they likely need to be removed from the organization and that organization's Medicare enrollment record to protect the organization. What they do with their own personal rehabilitation journey is on them, and it is not a slight to them, but it does protect the business that they are working for. Next slide, please. And I think on that note, I'm going to hand it over to Christin. Hello? I think we're having technical difficulties with Christin, so I'm going to keep chatting until she hopefully has a resolution with her microphone, but I'm going to keep going to make sure that we stay on top of everyone's time. We're going to go into revocation operational issues. We're going to specifically here, we're looking at reason 5, which is on-site review, and reason 2, which is excluded or debarred persons. Reason 5, on-site review, used to be a more popular basis for revocation based on on-site reviews, and it is currently still an issue. We've just seen these sorts of revocations come through in waves, and it's very important that you have signage for your agency that you're located where you say you are located in your 855, and that you have regular business hours. It's important that you post these hours, and then staff are there and operational during those hours. You should have somebody there answering the phone at the desk and making sure that person doesn't just leave for lunch because they decided they wanted to. You need to treat your office like it is, in fact, a true office. If CMS shows up for a site visit and the office was closed, somebody put a note on there saying they're out for lunch, back in 15 minutes, they're going to consider that as non-operational or otherwise closed.
Hey, Matt,
Another
can you
issue.
hear me now?
I can hear you now. Hi, Christin.
Fabulous. Well, I'll pick up right where you're leaving off.
Sure.
So another issue we're seeing is related to exclusions or debarments from the federal program, specifically whether there are any providers, suppliers, owners, managing employees, authorized or delegated officials, medical directors, supervisors, or other healthcare professionals who are excluded or debarred from Medicare, Medicaid, or any other federal healthcare program. If any of those people or entities are debarred or otherwise excluded from any other federal procurement or non-procurement program or activity, you can be revoked for that reason. So it's important that you're screening all of your employees regularly. We recommend monthly, and making sure that they are not excluded from participation. This is different than a background check. This is making sure you're looking at LEIE, GSA, SAM, and those available state lists to ensure that people aren't excluded. You need to check if they are somebody who's had a prior date, if they got married and changed their name. You need to make sure you're checking all iterations of that, because you can be revoked for that reason as well. There's a specific way to fix that issue that I'll discuss shortly, but it is a major reason we are seeing people get revoked. Okay, Gio, next slide, please. Perfect. As mentioned, state licensing and federal Medicare regulations require home health and hospices to have signage and post hours of operation. Please make sure that you have signs available along with those operational hours. You also need to have emergency contact numbers available in case somebody does show up and there is anybody available. This way the visitors can contact somebody at the office. Again, treat your office like a retail business. Plan for emergencies. If your regular receptionist is sick, who's going to cover the office? Make sure someone is available to answer the phone. You need to have a contingency plan. You can't just decide that you're closed for the day. We have seen cases where a site visit was actually done by phone. It was during a very busy time, and the provider did not answer the phone in what was considered a timely fashion. Several calls were made, but not answered timely, and there was no way for the surveyor or the site visitor to leave a message. The agency was then revoked based on that site visit that was attempted via phone. So it's very important that you answer the phone, you have an answering service or voicemail that can receive messages, and that you return any messages you receive in a timely fashion. So be checking and deleting those voicemail messages so your voicemail box doesn't end up full. Gio, next slide. A little bit more about exclusions and affiliations. It's very important that you are, in addition to screening for exclusions, looking at your owners or managing employees for things that can be considered something that would be an undue risk to the program. Have they ever worked at a company that is revoked? Have they ever worked at a company that owes an outstanding debt to Medicare? I know those sound familiar from when Matt was speaking earlier. Those are things that you can't screen for, and it's really difficult to identify that information. We are seeing an increase in the number of cases where CMS is using its authority to revoke agencies because of an affiliation issue. This is particularly challenging if, for example, you have a medical director who works at multiple agencies and one of those agencies gets revoked. You may have asked this question in the past, but as part of your monthly or regular screening process, it's important to consider continuing to ask these questions. For example, recently I've seen quite a few hospices that have been revoked because a medical director was affiliated with another revoked hospice, at least previously. There's a specific way to take corrective action that I'll touch on in a second. It's very important to make sure that you understand the individuals who are being considered managing employees. CMS does consider a hospice's medical director to be a managing employee, even though it's our position that if that person is a 1099, they're not really involved in any of the management decisions. So does that really make them a managing employee? It's a question of control, who has control over different types of decision-making capacities within the agency. So that's an argument you can make, but you don't want to have to be in the position to be making that argument in the first place. You want to make sure that the individuals you are contracted with, the individuals who are your owners, managing employees, and directors, those people don't have situations that would be considered posing an undue risk to the program, which includes any outstanding overpayments to the program. An undue risk might arise from an affiliation with a company that is currently revoked, somebody who is excluded or debarred, and people who may have licensing issues. Make sure you're doing background checks and exclusion checks. If you do identify a person who is excluded, or maybe you uncover somebody with an affiliation, you need to terminate that relationship. The relationship poses a risk to your agency. For the period when an excluded individual is affiliated with your agency, you may need to do some sort of refund to the government. There is a way to do that. Folks like Matt and I or other attorneys, are available to help walk you through that process. If your agency gets revoked based on an excluded individual, you need to remove the tainted person immediately and deliver proof to CMS within 15 days after receiving the revocation notice. That is a correction specifically in the regs for revocation for exclusions. Specifically, a revocation based on an excluded owner or managing employee must be terminated immediately and proof provided within 15 days after receiving the revocation notice. This makes opening your mail right away even more important. With such a narrow window for correction, you need to act quickly and get that notice into CMS. I know in some agencies there's a designated person who is responsible for opening mail. If that person is going to be on vacation for the week, somebody else needs to be opening the mail in the interim. We're seeing affiliation revocations similar to exclusions. We are in the process of appealing revocations of multiple agencies utilizing the same method of refuting the revocation based on affiliation. We're using the exclusion guidance to address termination of affiliated individuals within that 15-day time frame. You need to make sure you're acting quickly when you're getting some sort of notice like that. To prevent situations like this, you need to standardize your hiring process. Again, you need to make sure you're screening for exclusions. You can always contract out exclusion screenings. Just make sure that the company that you're hiring isn't just doing a background check or a licensing check. An exclusion check is a specific check of LEI, SAM, and the state lists, among others. A completely separate check for an excluded individual is something that happens after there's a final adverse action. I would also recommend that during your hiring practices, you're asking questions to identify these sorts of situations. Have you ever been affiliated with a company that owes a debt to Medicare? Have you ever been affiliated with a company that's been revoked? Like I said previously, there's not a way to screen for that, but you've got to try to protect yourself. If you do end up subsequently getting a revocation letter, that's evidence that you are trying to identify this and this person misled you when they didn't respond appropriately on their application or during their interview. The regulation says you have to make reasonable efforts to identify these affiliations with the disclosable events. It just doesn't specify what reasonable is. But we've generally told people we're happy to work with you to develop a list of questions to ask. For example, when you're hiring a medical director, what do you need to know about them? Let's develop a standardized list of questions you want them to respond to, preferably in writing, signed off and dated, so that you have something in your file that shows you did your due diligence. These are steps to take before hiring the person. Don't hire them and then start doing your due diligence. Incorporate it into your screening and hiring practices before they are actually an employee. And if you do identify an issue, obviously we want to take action. You don't want to ignore it. I would recommend reaching out to your legal counsel if you encounter a situation where you have been affiliated with someone and that affiliation seems to be problematic. They may have an affiliation revocation risk issue or somebody that's been excluded. I would absolutely recommend reaching out to counsel to kind of navigate the path forward. Next slide. Revocation issues, billing issues. This is a big revocation area that we're seeing, the abuse of billing privileges, specifically a pattern or practice of billing errors. Within the last 3 or 4 years, we've seen CMS use this revocation reason a lot, especially with the new Provisional Period of Enhanced Oversight Program, or PPEO. It's become the bane of my existence. And it really seems like they have just broadened their use of this revocation reason. For some background, CMS has discretion to determine if there's a pattern or practice of billing errors. As of 2022, the factors that were to be considered were the percentage of claims denied during the period under consideration, the provider's history of final adverse action or any such actions, the type of billing noncompliance, specific facts surrounding said noncompliance, and any other information regarding the provider or supplier's specific circumstances that CMS deems relevant to its determination. So basically, anything else it wants to consider, it can. And in determining whether or not a provider has a pattern or practice of billing errors, one of the things you didn't hear me list off is the number of claims denied or the total number of claims considered. It's just a percentage base. So this revocation reason is specifically driven by data mining and audit activity by MACs and UPICs and the PPEO groups now. They're doing investigations and reporting back to the MAC about the results they're seeing. If they're doing a subsequent audit, is there an improvement on those claims, a decreased error rate, resolution of specific denial rationale, or is it more of the same? The problem with this revocation reason is that you really are having to pursue 2 appeals at the same time, one for the denied claims and one for the revocation action. If you are heavily reliant on Medicare, you're in a really challenging situation financially while you're trying to take on 2 rather substantive appeals. Appeals can be very expensive and extraordinarily stressful situations because the administrative appeals process is not a fast process. And while you may be familiar with the appeals process for claims specifically, where you go through level 1 and you go through level 2 and the timeframes that are associated with that, going through the revocation appeals process is an unknown. Although CMS and their contractors are supposed to issue decisions based on a specific time frame, and you are held to those timeliness requirements quite strictly, we are not seeing the same kind of turnaround on the revocation appeals action. So these are taking an enormous amount of time to move through the process. So some examples for you. One hospice was suspended for a credible allegation of fraud and then revoked following repeated UPIC audits. This is what we initially saw when CMS was ramping up its use of this revocation reason. We saw a number of cases where there were repeated UPIC audits, typically 3 in a row with high error rates that led to revocation. CMS does not disclose when an excessively high error rate is or what improvement must be achieved between audits. 3 strikes and you're out is not the rule of thumb for the PPEO program. Texas is included in this program, and we're seeing these types of audits for agencies that have undergone a change of ownership or 100% change in shareholders or members. Texas is among other states currently affected, Arizona, California, and Nevada. It's rumored that CMS intends to bring this program nationwide, so if you have agencies in other areas, it's something to look out for. But in the states currently seeing these audits, revocations have been very aggressive for minimal numbers of claims. In some cases, the total number of claims reviewed is less than 10. And a second round of PPEO review has not been completed. Regardless of where the audit comes from, take advantage of your appeal options, even if the overpayment amount is small. It's very important that you assert those appeal rights and take those claims through the administrative appeals process. Too often, we are seeing revocations that state the agency has failed to challenge the accuracy of denial rationale or to make improvements despite the provision of education by CMS. CMS takes education to mean that little letter they send you with the denial rationale. That's sufficient to qualify as education for them. Next slide. So this is some language that comes straight off a TPE result letter and language that comes off a UPIC letter. They're putting this message out there that you can be revoked. So the language from the TPE result letter is after 3 rounds of TPE review with continued high denials. Palmetto GBA will refer the provider to CMS for additional, I apologize, all my dogs do not like the delivery man. Will refer the provider to CMS for additional action, which may include 100% prepayment review, extrapolation, referral to a recovery auditor, etc. UPIC letters reiterate CMS's authorization to revoke Medicare billing privileges under certain conditions. In particular, we know that CMS has the authority to revoke the currently enrolled provider or supplier's Medicare billing privileges if CMS determines the provider or supplier has a pattern or practice of submitting claims that fail to meet the Medicare requirements. Consider these sparse statements your official warning. They're putting it right out there for you in the audit decisions, which are considered education, like I mentioned. And it's usually at the very end of the letter in an offhand kind of paragraph. They're definitely not drawing attention to these particular statements. If there isn't a change in your billing practices and you don't appeal the decision or have success on the appeal, then they'll come back to do another audit in a lot of cases. If there's no change with a continuing high error rate, they're going to start considering that a pattern or practice of billing errors is present. Next slide. So how do we prevent this? Like I said previously, if there is an error and you fix it, and you can fix it, do. Don't just allow issues to remain. You need to fix problems. If you're notified that there's an issue with how your documentation is being prepared and it needs to be corrected to meet the coverage requirements, fix the documentation. Don't fix it retroactively and inappropriately because that can be considered fraud. You do need to take corrective action so that going forward, your claims meet the coverage requirements and you show that you're trying to be a good corporate citizen. You've been educated and now are taking the right steps moving forward to make sure that you're in compliance. You need to have a compliance program that is suitable to your business. That compliance program needs to include regular claim auditing. That can be internal claim auditing, or you can use an outside company to do outside reviews. But you need to have some sort of QA process to look at your documentation and make sure it's meeting the coverage requirements. You should also know your denial reasons and work to reduce the frequency of those occurring. Provide feedback to your clinical staff on their documentation. A lot of providers aren't getting educated about how to document when they're in school. That's something that is just kind of institutional knowledge. They learn as they go. It's really important that you educate these providers on what you need to have to meet the coverage requirements so that you are in a good position. If you are in a claims audit, make sure you do a deep dive on your entire claim. This can be part of your compliance review. You need to look at the records. You need to look at the claims. You need to look at the ERA and verify that everything is matching up. You can get some paper ERAs for Medicare and other payers to verify that they match what you received electronically. There are times we're seeing there are issues between the EMR system and the clearinghouse. Something goes awry in the process. You need to make sure all of the information is accurate. Some providers, unbeknownst to them, have overpayment or billing errors because of the way their systems are set up. Those systems are not necessarily talking to each other the way they're supposed to, causing errors. Again, appeal your individual claim denials, appeal a UPIC decision, appeal a SMRC decision, appeal the PPEO decision. If it's unfavorable, appeal it. If you do not appeal those denials, then CMS is going to take the position that you agreed with what they said, even though you may just be paying it because resources are limited, and paying it and not appealing it is more cost effective, and you may not have the resources to deal with hiring an attorney to fight an appeal. Regardless of who prepares it for you, you need to appeal those denials. So CMS doesn't take the position that you agreed with the unfavorable decision. If you don't make any changes based on your documentation and they come back and look again, there's a high chance that you will subsequently get revoked just because of the position that CMS seems to be taking on this specific revocation reason. Next slide. Okay, so I want to take a few minutes to kind of talk about the appeals process. What happens if you do get revoked? So if you do receive a revocation letter, you need to identify the effective date first. Sometimes, especially if it's based on a felony, for example, it can be before you receive the revocation letter, or if it's based on the site visit, it can be the day that they did the site visit. You need to make sure that is the first thing you look at. Is it a revocation that is being retroactively applied, or is it a revocation action that's going to take effect 30 days from the date of the letter, which for revocation reasons that are outside of site visits, felony convictions, and exclusions is generally 30 days. You're going to be revoked on that day 30, even if we're appealing the revocation. It doesn't matter. You're still going to be out of the program the entire time you're fighting that revocation. Something else that's important to think about is that Medicaid does have the authority to revoke. We don't always see that happen immediately, but we do in some situations. In some states, you go through the administrative appeal process first, and then that occurs. So know kind of what your state's process is. Private payer contracts often require that you report the revocation to them, and you typically also need to report it to the accrediting body if your agency or business is accredited. We also see these get reported to NPDB as well. Something else to keep in mind, that there could be a report to NPDB as well that you're going to need to respond to. So it's just another area that's going to pull your focus and require more attention. Next slide, please. What if the worst happens? If you do get a revocation letter, you need to immediately call your healthcare counsel or find a healthcare lawyer that can help you. You need to discuss the appeal and alternative business arrangements that can help keep you in business. Revocations are not the time to do it yourself. This is your business that is on the line. There are very tight appeal deadlines. There are strict rules on the submission of evidence. So it's very important you take this seriously and take action promptly so that the attorney you're working with has time to prepare a proper appeal. You have 60 days from the date of the revocation letter to file a reconsideration appeal. In some instances, for example, if you are revoked for noncompliance, then you can submit a corrective action plan. This has to be submitted within 30 days. If you're revoked for that specific reason and you are submitting a corrective action plan, the corrective action plan doesn't stay the timeline for the reconsideration. You have 3 deadlines, really, when dealing with these revocations that occur simultaneously. 15 days for an excluded or affiliated individual, 30 days for a compliance plan, and 60 days for the reconsideration appeal. These deadlines are not one after another. They're simultaneous. Keep tabs on the tight deadlines and what materials and evidence needs to be submitted for each. If the corrective action plan is successful, then CMS will just kind of say that the reconsideration is moot. As I mentioned, it's very important that you know that filing the CAP does not pause your reconsideration appeal timeline. If you have an affiliation, revocation reason, or an exclusion to suspension to bar a person, again, like I said previously, take immediate action, terminate that person immediately, and then get evidence over to CMS or to the MAC, depending on who your appeal goes to. You also need to develop a plan for your business, such as alternative business arrangements. You need to review your payer contracts, develop a plan to address reduction of staff while retaining necessary personnel while you transition patients to new providers. You'll need to conduct a realistic financial analysis of how long you're going to be able to stay in business and continue operating while you're revoked from Medicare participation, because it can take 90 days to get a decision on that initial appeal. In an ideal situation, 90 days. That is not what we're seeing currently, and that is a critical piece of information to also consider. I have revocation appeals that are 6 and 8 months old right now, and it is not for lack of pursuing the folks at CMS who need to issue the decisions. It is just a delay in getting the decisions actually issued. Next slide. So appeals procedure. I just went over the corrective action plans. Again, 30 days to file those. You can fix a failure to report. You can't fix a failure to report. You can, however, address mistakes that the contractor made, like failing to acknowledge an update that you sent. You can also utilize sometimes for DME or IDTF standard violation issues. It usually takes 30 to 90 days to get a response. Again, you have 60 days to file the reconsideration. The most important thing about reconsideration is your evidentiary milestone. If there's anything, this is your evidentiary milestone. If there's anything you want to consider in your appeal, it needs to be submitted with your reconsideration appeal. Everything you want considered needs to be in that first submission, which is why it's important to get your attorney involved early so they have time to get all of that documentation from you and get it prepared and incorporated into a cohesive appeal. It used to typically take about 90 days to get a response back from either the contractor or the provider enrollment oversight group, whoever the appeal is supposed to go to. I am still seeing the 90-day when it's going to the contractors. PEOG is taking substantially longer to get decisions back. It's important that you make all of your arguments, your factual and legal arguments in this reconsideration, and that you address all of the revocation reasons, or you will not be able to preserve those for a subsequent appeal. Next slide. If your reconsideration appeal is unsuccessful, you do have additional appeal opportunities, even if you cannot submit additional evidence. You can go to the Department of Appeals Board of the Civil Remedies Division. You can file a request for hearing, which is due within 60 days of the reconsideration decision. I will say this is like a formal court procedure and includes briefing. There is an attorney assigned from CMS from the regional office, and each side briefs the case and provides the evidence it can make. There are motions in the case as well. You can request a hearing to cross-examine witnesses, but the judge can also decline and decide the case on the briefs alone. The rules state that they try to resolve these cases within 180 days, but it can take longer than that. CMS will consider settling cases at this stage, but you have to show a compelling reason why the case should be settled. It's really important to have an attorney involved at this level. If you do get somebody involved at the earlier level, obviously that's our preference to get them in at reconsideration. But I highly recommend an attorney if you're going to be filing for an ALJ. If your ALJ appeal is unsuccessful, you do have an option to appeal to the Department of Appeals Board Appellate Division, and this has appellate rules that apply. This is typically a case that is reviewed on the record, meaning without a hearing, from the administrative record, from the ALJ review. Of course, you can always also appeal to the federal court if your appellate division decision is unfavorable. That typically needs to be filed within 60 days of that lower level decision, and you must go through all the prior steps first. You have to exhaust your administrative appeals rights before you go to federal court. However, there can be, a substantial cost associated with filing in federal court. Remember, during this period of time, when you're revoked, you're not receiving any funds coming in from CMS on any of those services. Next slide. Stay of enrollment. Quickly, I just want to talk about this, which is relatively new. CMS issued an MLN Matters article that indicated that contractors could start using this as of May 30th, 2024, so a little over a year and a half ago. We've only seen a handful since then. It is less burdensome than an actual deactivation or revocation of Medicare enrollment. A stay is essentially preliminary interim status. That is kind of a pause on enrollment. It does not require a full initial application as a new provider to remove the stay and reactivate billing privileges. This typically becomes an option if you've been non-compliant with at least one of the Medicare enrollment requirements. that can be remedied. You can remedy it by submitting an enrollment form, so submitting an 855 with the correct information. Some examples are if you fail to timely report a change in address, fail to timely revalidate, or fail to report the deletion of a managing employee. You can utilize this to submit that corrected enrollment form, and instead of being deactivated and having a potential gap in enrollment, this can correct the enrollment error and you won't have that gap. You remain enrolled during the stay. Claims can be rejected during the stay, but if you get reactivated, you're not going to have a gap like you would if you were deactivated and then there was a time period where you had not submitted a corrected 855. This is not considered an adverse legal action. The stay is no longer than 60 days, but it can be imposed multiple times. So if you have an issue with your revalidation, you fix it. If you then subsequently have an issue with, say, a failure to report a change of address, you may get another stay. So it's not like a one-time thing. We've only seen this being utilized so far in connection with failures to revalidate, but I expect that we'll see more of it. Keep an eye on your mail. Again, it's important to know that this is something that we're seeing. It's a great option because you won't have that gap in your enrollment where you've lost revenue that you'll have to fight over. If you do see a revocation letter with a stay, make sure you get that corrected immediately so that you don't have a deactivation issue. All right, I think that's it. We have just a couple of minutes for any questions that might have popped up during all of our discussions about all of these revocation issues. Gio, did you see any come in?
No, I do not see any questions come in, nor
Okay.
anything else. So I think you guys got to the point. But anyways, so that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Matt and Christin. Everyone from today's webinar will receive copies of the presentation tomorrow via email. And if you have any further questions that didn't get through today about today's discussion or another healthcare law issue, please feel free to reach out to Matt Catoe or Christin Thompson, or directly to Laos Parker. Other than that, have a good Wednesday and take care.
Thanks.
Thank you guys.